Good morning, Cynthia.
Good morning.
Today we have jury charge speed building, so let me give you some words on your speed building, okay? Just a minute, let me see. Okay, we have Akron, Ohio, Dr. Wayne Scott, Dr. Ben Geyer, undisputed, Robert Duff, Dr. Richard Rains, irretrievable, and neurological. Any questions on anything there, Cynthia?
No.
No? Okay, so this is going to be then, I'm going to start at 180, or do you want me to start 190? I'm going to start at 190, and it's going to be for 5 minutes jury charge, okay?
Okay.
Members of the jury, you have heard the evidence and the arguments of counsel. It now becomes my duty to give the lawful instructions of the court as to the law applicable to this case. It is the undisputed evidence that at approximately 6 o'clock in the morning on September 1, 1980, Robert Duff, an employee of the Home Style Restaurant in Akron, Ohio, was discovered lying on the floor near the kitchen area in the restaurant. Mr. Duff had been shot in the head but was still breathing, and his pulse was definable. The ambulance arrived approximately at 6:20, and at that time, Mr. Duff was still breathing and still had a pulse and distinguishable blood pressure. Mr. Duff arrived at the hospital at 6:55 in the morning. Dr. Wayne Scott, the emergency room physician, made a preliminary observation and immediately called Dr. Richard Rains, a neurological surgeon. Dr. Rains found Mr. Duff had suffered irretrievable brain damage and advised Mr. Scott that Mr. Duff could be pronounced dead at any time. The family was notified that Mr. Duff could be maintained by artificial means for an indefinite period of time. The family definitely decided not to prolong life by artificial means and asked that Mr. Duff's kidneys be transplanted. Both kidneys were removed at approximately 9:30 in the morning by Mr. or Dr. Ben Geyer. Prior to the removal of the kidneys, Dr. Geyer examined Mr. Duff and determined he was in fact dead. This is a criminal case commenced by the prosecution against the defendant. The case is based on an indictment which reads as follows. Count 1 of the indictment charges the defendant with first-degree murder. It is important that you understand that an indictment is simply a charge and that it is not in any sense evidence of the allegations it contains. The defendant has pleaded not guilty to the indictment and claims that the death of Mr. Duff was caused by the operation performed by the doctors at the hospital. The prosecution therefore has the burden of proving each of the essential elements of the indictment beyond a reasonable doubt. The purpose of this trial is to determine whether the prosecution has met this burden. In regard to count 1 of the indictment, defendant claims that the kidney transplant was the cause of the death of Robert Duff and not the gunshot wounds to the head. You are instructed in this regard that if you find defendant did cause the wounds to be inflicted on the person of Robert Duff, then you must determine whether the act of the defendant contributed to the death of Robert Duff. If you find defendant's acts contributed to the death of Robert Duff, then responsibility cannot be avoided by the fact that independent causes such as the negligence of others also contributed to the death. However, if you find the cause of death resulted solely from erroneous treatment by the physicians, you must acquit the defendant of the offense charged in count 1. I will now instruct you in what is, in this case, an important issue. The issue is the definition of death. A person will be considered medically and legally dead if, in the opinion of a physician based on ordinary standards of medical practice, there is the absence of spontaneous respiratory and cardiac function, and because of the disease or condition which caused directly or incorrectly these functions to cease, or because of the passage of time since these functions ceased, attempts at resuscitation are considered hopeless, and in this event, death will have occurred at the time these functions ceased, or a person will be considered medically and legally dead if, in the opinion of a physician based on ordinary standard of medical practice, there is the absence of spontaneous brain function, and if based on ordinary standards of medical practice during reasonable attempts to either maintain or restore spontaneous circulatory or respiratory function in the absence of aforesaid brain function, it appears that further attempts at resuscitation or supportive maintenance will not succeed. Death will have occurred at the time when these conditions first coincide. Death is to be pronounced before artificial means of supporting respiratory and circulatory function are terminated and before any vital organ is removed for purposes of transplantation. Murder in the first degree, members of the jury, is the unlawful killing of a human being by another with malice aforethought, either express or implied. Murder in the first degree is committed when 1, it is committed purposely or knowingly, or 2, it is committed recklessly under circumstances manifesting extreme indifference to the value of human life. You have heard testimony from witnesses who have testified because they possess special skill or knowledge in some science, profession, or business which is not common to the average man and which is possessed by the expert by reason of his special study or experience. These witnesses were qualified to speak by reason of their special training, skill, or familiarity with the subject. You have heard the evidence of persons who are skilled in some art, science, profession, or business which skill or knowledge is not common to their fellow men and which has come to such experts by reason of special study and experience in such art, science, profession, or business. Thus, the expert witnesses testified here to assist you, the trier of the fact, to understand the evidence and determine facts in issue. It is the province of the jury to decide the credibility of each witness and the weight to be given his or her testimony. In weighing the testimony of each witness, you members of the jury should consider his or her relationship. Any questions there, Cynthia?
Yeah, there was one word. Let me see if I can find it.
Transplanted? No. Let me give you some. Okay, and I'm just going to write some words in the meantime, okay, because there's a lot of briefs in here. Let me just write them down for you. You look back and see if you can find it. I've got in the morning is Nern. So, sorry, can't write. Oh, there it is, NERNG. Emergency room is MRJ with an asterisk. There it is. MRM with an asterisk. If you think of it, just say it, Cynthia.
Okay.
Transplant is transplant. Sorry, I have nails and it just doesn't. There it is. Okay. Essential is sexual. Prosecution, PRGS. Gunshot wounds is GUNDZ. There it is, GOUNDZ. Malice aforethought, Maffert. Malice aforethought, Maffert. Murder in the first degree is MUFRD with an asterisk. Any of them, Cynthia?
No, I can't find it.
Okay, and possess is PESZ. Okay, this is going to be then, how about, is it, no, I didn't even say that. Okay, this is going to be then, Cynthia, out 200. Is it hard?
It's a little challenging.
Okay, 200 for 5 minutes. Members of the jury, you have heard the evidence and the arguments of counsel. It now becomes my duty to give the lawful instructions of the court as to the law applicable to the case. It is the undisputed evidence that at approximately 6 o'clock in the morning on September 1, 1980, Robert Duff, an employee of the Homestyle restaurant in Akron, Ohio, was discovered lying on the floor near the kitchen area in the restaurant. Mr. Duff had been shot in the head but was still breathing and his pulse was definable. The ambulance arrived at approximately 6:20 and at that time Mr. Duff was still breathing and still had a pulse and distinguishable blood pressure. Mr. Duff arrived at the hospital at 6:55 in the morning. Dr. Wayne Scott, the emergency room physician, made a preliminary observation and immediately called Dr. Richard Rains, a neurological surgeon. Dr. Rains found Mr. Duff had suffered irretrievable brain damage and advised Dr. Scott that Mr. Duff could be pronounced dead at any time. The family was notified that Mr. Duff could be maintained by artificial means for an indefinite period of time. The family asked and decided not to prolong life by artificial means and asked that Mr. Duff's kidneys be transplanted. Both kidneys were removed at approximately 9:30 in the morning by Dr. Ben Geyer. Prior to the removal of the kidneys, Dr. Geyer examined Mr. Duff and determined he was in fact dead. This is a criminal case commenced by the prosecution against the defendant. The case is based on an indictment which reads as follows. Count 1 of the indictment charges the defendant with first-degree murder. It is important that you understand that an indictment is simply a charge and that it is not in any sense evidence of the allegations it contains. The defendant has pleaded not guilty to the indictment and claims that the death of Mr. Duff was caused by the operation performed by the doctors at the hospital. The prosecution therefore has the burden of proving each of the essential elements of the indictment beyond a reasonable doubt. The purpose of this trial is to determine whether the prosecution has met this burden. In regard to count 1 of the indictment, defendant claims that the kidney transplant was the cause of the death of Robert Duff and not the gunshot wounds to the head. You are instructed in this regard that if you find the defendant did cause the wounds to be inflicted on the person of Robert Duff, then you must determine whether the act of the defendant contributed to the death of Robert Duff. If you find defendant's acts contributed to the death of Robert Duff, then responsibility cannot be avoided by the fact that independent causes such as the negligence of others also contributed to the death. However, if you find the cause of death resulted solely from erroneous treatment by the physicians, you must acquit the defendant of the offense charged in count 1. I will now instruct you what is, in this case, an important issue. That issue is the definition of death. A person will be considered medically and legally dead if, in the opinion of a physician based on ordinary standards of medical practice, there is the absence of spontaneous respiratory and cardiac function, and because of the disease or condition which caused directly or indirectly these functions to cease, or because of the passage of time since these functions ceased, attempts at resuscitation are considered hopeless, and in this event, death will have occurred at the time these functions ceased, or a person will be considered medically and legally dead if, in the opinion of a physician based on ordinary standard of medical practice, there is an absence of spontaneous brain function, and if based on ordinary standards of medical practice, during reasonable attempts to either maintain or restore spontaneous circulatory or respiratory function in the absence of aforesaid brain function, it appears that further attempts at resuscitation or supportive maintenance will not succeed. Death will have occurred at the time when these conditions first coincide. Death is to be pronounced before artificial means of supporting respiratory and circulatory function are terminated and before any vital organ is removed for purposes of transplantation. Murder in the first degree, members of the jury, is the unlawful killing of a human being by another with malice aforethought, either expressed or implied. Murder in the first degree is committed when 1. It is committed purposely or knowingly, or 2. It is committed recklessly under circumstances manifesting extreme indifference to the value of human life. You have heard testimony from witnesses who have testified because they possess special skill or knowledge in some evidence, profession, or business which is not common to the average man and which is possessed by the expert by reason of his special study or experience. These witnesses were qualified to speak by reason of their special training, skill, or familiarity with the subject. You have heard the evidence of persons who are skilled in some art, science, profession, or business, which skill knowledge is not common to their fellow men and which has come to such experts by reason of special study and experience in such art, science, profession, or business. Thus, the expert witnesses testified here to assist you, the trier of the fact, to understand the evidence and determine the facts in issue. It is the province of the jury to decide the credibility of each witness and the weight to be given to his or her testimony. In weighing the testimony of each witness, you members of the jury should consider his or her relationship to the parties in the case, the witness's interest, if any, on the outcome of the case, his or her manner of testifying, his or her truthfulness, fairness, and intelligence, and the extent to which he or she has been. Did you remember what it was, Cynthia?
More in the beginning. It starts with a, yeah, it starts like with a D or B.
Let me see. Discovered?
It's distinguished.
Oh, DWISH. DWIRB, because sometimes the W will act as a V. DWISH. Anything else, Cynthia?
No, that's the one I kept getting caught up on.
Okay, DWISH. At any time is TNT with an asterisk, initial T, final NT with an asterisk. Indictment is DINT, D long IMT. You have in fact is NFT. And then there was one more I wanted to give you. Physician, FGS. And then this is going to be of course, corroborate is KROBT or KRBT. No, corroborate, two strokes, sorry, corroborate. And this is going to be at, any other, Cynthia?
No.
Okay, spontaneous is like that, 3 strokes, spontaneous. This is going to be at 2:10. Members of the jury, you have heard the evidence and the arguments of counsel. It now becomes my duty to instruct you and give you the lawful instructions of the court as to the law applicable to this case. It is the undisputed evidence that at approximately 6 o'clock in the morning on September 1, 1980, Robert Duff, an employee of the Homestyle restaurant in Akron, Ohio, was discovered lying on the floor near the kitchen area in the restaurant. Mr. Duff had been shot in the head but was still breathing and his pulse was definable. The ambulance arrived approximately at 6:20, and at that time, Mr. Duff was still breathing and still had a pulse and distinguishable blood pressure. Mr. Duff arrived at the hospital at 6:55 in the morning. Dr. Wayne Scott, the emergency room physician, made a preliminary observation and immediately called Dr. Richard Rains, a neurological surgeon. Dr. Rains found that Mr. Duff had suffered irretrievable brain damage and advised Dr. Scott that Mr. Duff could be pronounced dead at any time. The family was notified that Mr. Duff could be maintained by artificial means for an indefinite period of time. The family definitely decided not to prolong life by artificial means and asked that Mr. Duff's kidneys be transplanted. Both kidneys were removed at approximately 9:30 in the morning by Dr. Ben Geyer. Prior to the removal of the kidneys, Dr. Geyer examined Mr. Duff and determined he was in fact dead. This is a criminal case commenced by the prosecution against the defendant. The case is based on an indictment which reads as follows. Count 1 of the indictment charges the defendant with first-degree murder. It is important that you understand that an indictment is simply a charge and that it is not in any sense evidence of the allegations it contains. The defendant has pleaded not guilty to the indictment and claims that the death of Mr. Duff was caused by the operation performed by the doctors at the hospital. The prosecution therefore has the burden of proving each of the essential elements of the indictment beyond a reasonable doubt. The purpose of this trial is to determine whether the prosecution has met this burden. In regard to count 1 of the indictment, defendant claims that the kidney transplant was the cause of the death of Robert Duff and not the gunshot wounds to the head. You are instructed in this regard that if you find defendant did cause the wounds to be inflicted on the person of Robert Duff, then you must determine whether the act of the defendant contributed to the death of Robert Duff. If you find defendant's acts contributed to the death of Robert Duff, then responsibility cannot be avoided by the fact that independent causes such as the negligence of others also contributed to the death. However, if you find the cause of death resulted solely from erroneous treatment by the physicians, you must acquit the defendant of the offense charged in count 1. I will now instruct you in what is in this case an important issue. That issue is the definition of death. A person will be considered medically and legally dead if, in the opinion of a physician based on ordinary standards of medical practice, there is the absence of spontaneous respiratory and cardiac function, and because of the disease or condition which caused directly or indirectly these functions to cease, or because of the passage of time since these functions ceased, attempts at resuscitation are considered hopeless, and in this event, death will have occurred at the time these functions ceased, or a person will be considered medically and legally dead if, in the opinion of a physician based on ordinary standard of medical practice, there is the absence of spontaneous brain function, and if based on ordinary standards of medical practice during reasonable attempts to either maintain or restore spontaneous circulatory or respiratory function in the absence of aforesaid brain function, it appears that further attempts at resuscitation or supportive maintenance will not succeed. Death will have occurred at the time when these conditions first coincide. Death is to be pronounced before artificial means of supporting respiratory and circulatory function are terminated and before any vital organ is removed for purposes of transplantation. Murder in the first degree, members of the jury, is the unlawful killing of a human being by another with malice aforethought. Either express or implied murder in the first degree is committed when 1, it is committed purposely or knowingly, or 2, it is committed recklessly under circumstances manifesting extreme indifference to the value of human life. You have heard testimony from witnesses who have testified because they possess special skill, knowledge, and science, profession, or business which is not common to the average man and which is possessed by the expert by reason of his special study or experience. These witnesses were qualified to speak by reason of their special training, skill, or familiarity with the subject. You have heard the evidence of persons who are skilled in some art, science, profession, or business, which skill or knowledge is not common to their fellow men and which has come to such experts by reason of special study and experience in such art, science, profession, or business. Thus, the expert witnesses testified here to assist you, the trier of the fact, to understand the evidence and determine the facts and issue. It is the province of the jury to decide the credibility of each witness and the weight to be given his or her testimony. In weighing the testimony of each witness, you members of the jury should consider his or her relationship to the parties in the case, the witness's interest, if any, on the outcome of the case, his or her manner of testifying, his or her truthfulness, fairness, and intelligence, and the extent to which he or she has been corroborated or contradicted, if at all, by other credible evidence. If you, members of the jury, believe that a witness has sworn falsely to a material fact in this case, you may disregard his or her testimony in whole or in part. You are not bound by any opinions which you may think I have about the facts in the... And anything there, Cynthia, any words that came out?
No.
No? Okay, and if you don't have a brief or credible evidence, you can write KRE, FD, or BD. They both come out. You ready for readback?
I'll try.
Okay. This is going to be 200 readback, okay?
Okay.
Members of the jury, you have heard the evidence and the arguments of counsel. It now becomes my duty to give the lawful instructions of the court as to the law applicable to this case. It is the undisputed evidence that at approximately 6 o'clock in the morning on September 1, 1980, Robert Duff, an employee of the Homestyle restaurant in Akron, Ohio, was discovered lying on the floor near the kitchen area in the restaurant. Mr. Duff had been shot in the head but was still breathing and his pulse was definable. The ambulance arrived at approximately, it was only 30 seconds. And whenever you're ready, I'm ready.
Okay. Okay, members of the jury, you have heard the evidence and the arguments of counsel. It now becomes my duty to give the lawful instruction of the court.
Instructions, plural.
Instructions of the court as to the law applicable in this case.
To this case?
To this case?
Yes.
Okay. Okay, it is the undisputable.
Undisputed.
I have that too. Undisputed evidence that at approximately 6 o'clock in the morning on September 1, 1980, Robert, is it Duff?
Yes, Duff.
Robert Duff in
And
Akron.
employee,
I have in Akron, Ohio.
an employee of the Homestyle restaurant in Akron, Ohio.
Was discovered dying on the floor.
Lying.
Oh, lying on the floor in the kitchen area in the restaurant. Mr. Duff was shot in the head.
Had been shot.
Had been shot in the head and was still.
But was still
breathing, and the pulse was still.
And his pulse was.
And his pulse was still.
Was definable.
And then I have arrived. The ambulance arrived at approximately.
Good, good. So good. You just want to focus on having what you have correct. Okay, good, Cynthia. Are you going to stay on for the live tests?
Yeah, I think I'm going
to go faster. I'm going to go faster and then I'll do the live tests.
Yes, I think I am.
Okay, good. So this is going to be faster than 210. Okay, Cynthia? And just remember, try and get everything accurately, okay? Here we go. 210, and then I'll give you tests. Members of the jury, you have heard the evidence and the arguments of counsel. It now becomes my duty to give the lawful instructions of the court as to the law applicable to this case. It is the undisputed evidence that at approximately 6 o'clock in the morning on September 1, 1980, Robert Duff, an employee of the Homestyle restaurant in Akron, Ohio, was discovered lying on the floor near the kitchen area in the restaurant. Mr. Duff had been shot in the head but was still breathing and his pulse was definable. The ambulance arrived at approximately 6:20, and at that time Mr. Duff was still breathing and still had a pulse and distinguishable blood pressure. Mr. Duff arrived at the hospital at 6:55 in the morning. Dr. Wayne Scott, the emergency room physician, made a preliminary observation and immediately called Mr. or Dr. Richard Rains, a neurological surgeon. Dr. Rains found Mr. Duff had suffered irretrievable brain damage and advised Dr. Scott that Mr. Duff could be pronounced dead at any time. The family was notified that Mr. Duff could be maintained by artificial means for an indefinite period of time. The family definitely decided not to prolong life by artificial means and asked that Mr. Duff's kidneys be transplanted. Both kidneys were removed at approximately 9:30 in the morning by Dr. Ben Geyer. Prior to the removal of the kidneys, Dr. Geyer examined Mr. Duff and determined that he was in fact dead. This is a criminal case commenced by the prosecution against the defendant. The case is based on an indictment which reads as follows. Count 1 of the indictment charges the defendant with first-degree murder. It is important that you understand that an indictment is simply a charge and that it is not in any sense evidence of the allegations it contains. The defendant has pleaded not guilty to the indictment and the claims that the death of Mr. Duff was caused by the operation performed by the doctors at the hospital. The prosecution, therefore, has the burden of proving each of the essential elements of the indictment beyond a reasonable doubt. The purpose of this trial is to determine whether the prosecution has met this burden. In regard to count 1 of the indictment, defendant claims that the kidney transplant was the cause of death of Robert Duff and not the gunshot wounds to the head. You are instructed in this regard that if you find defendant did cause the wounds to be inflicted on the person of Robert Duff, then you must determine whether the act of the defendant contributed to the death of Robert Duff. If you find defendant's acts contributed to the death of Robert Duff, then responsibility cannot be avoided by the fact that independent causes such as the negligence of others also contributed to the death. However, if you find the cause of death resulted solely from the erroneous treatment by the physicians, you must acquit the defendant of the offense charged in count 1. I will now instruct you in what is, in this case, an important issue. That issue is the definition of death. A person will be considered medically and legally dead if, in the opinion of a physician, based on ordinary standards of medical practice, there is the absence of spontaneous respiratory and cardiac function, and because of the disease or condition which caused directly or indirectly these functions to cease, or because of the passage of time since these functions ceased, attempts at resuscitation are considered hopeless, and in this event, death will have occurred at the time these functions ceased, or a person will be considered medically and legally dead if, in the opinion of a physician, based on ordinary standard of medical practice, there is the absence of spontaneous brain function, and if based on ordinary standards of medical practice during reasonable attempts to either maintain or restore spontaneous circulatory or respiratory function in the absence of aforesaid brain function, it appears that further attempts at resuscitation or supportive maintenance will not succeed. Death will have occurred at the time when these conditions first coincide. Death is to be pronounced before artificial means of supporting respiratory and circulatory function are terminated and before any vital organ is removed for purposes of transplantation. Murder in the first degree, members of the jury, is the unlawful killing of a human being by another which, with malice aforethought, either express or implied. Murder in the first degree is committed when 1, it is committed purposely or knowingly, or 2, it is committed recklessly under circumstances manifesting extreme indifference to the value of human life. You have heard testimony from witnesses who have testified because they possess special skill or knowledge in some science, profession, or business which is not common to the average man and which is possessed by the expert by reason of his special study or experience. These witnesses were qualified to speak by reason of their special training, skill, or familiarity with the subject. You have heard the evidence of persons who are skilled in some art, science, profession, or business, which skill or knowledge is not common to their fellow men, and which has come to such experts by reason of special study and experience in such art, science, profession, or business. Thus, the expert witnesses testified here to assist you, the trier of the fact, to understand the evidence and determine the facts in issue. It is the province of the jury to decide the credibility of each witness and the weight to be given to his or her testimony. In weighing the testimony of each witness, you, the members of the jury, should consider his or her relationship to the parties in the case, the witness's interest, if any, on the outcome of the case, his or her manner of testifying, his or her truthfulness, fairness, and intelligence, and the extent to which he or she has corroborated or been corroborated or contradicted, if at all, by other credible evidence. If you, members of the jury, believe that a witness has sworn falsely to a material fact in this case, you may disregard his or her testimony in full or in part. You are not bound by any opinions which you may think I have about the facts in the case. And then I'm going to read a 220 jury charge, and so that way you also get a little bit of speed building. Any questions, Cynthia?
No.
Okay. And so I wanted to give you blood pressure is BLP. If you don't have a brief, and some people also can do PLOOP, BLAOP for blood pressure. And so we'll get ready for your test. I'm going to start with the 220 and proper names that come out. You have none. I do see court capitalized. If the court when you can replace judge in the sentence, and it's D-O-U-R-T, and it'll come out capped, okay? Are you ready, Cynthia?
Yes, I'm ready.
I'm going to mute you, and I'm going to start with your 220 jury charge for 5 minutes. Good luck. $220 jury charge. Members of the jury. The jury are the sole judges of the facts in the case, the credibility of the witnesses, and the weight to be given to their testimony. In anything that the court may have said throughout the trial, or anything that the court may have said in the instructions, the court does not intend to express any opinion upon the facts of the case, upon the credibility of the witnesses, nor on the weight to be given to their testimony. The court instructs the jury that the court is the sole judge of the law in this case, and it becomes the duty of the jury to follow the law as it is given to you by the court in these instructions. You have no right to disregard any portion of the instructions, but you are bound to take all of them as they are given to you by the court and apply them as to this case. The jury are the sole judges of the credibility of the witnesses. Your verdict should not be determined by the number of witnesses testifying on either side. However, you may take into consideration the number of witnesses testifying in support of or against any fact. The same rules outlined here are to be applied to the testimony given by the defendant. You have no right to disregard the testimony of the defendant simply because he is accused of a crime. The law says that one accused and charged with the commission of a crime may testify in his own behalf or not, as he so decides. The court instructs the jury that if the defendant does testify in his own behalf, then you have no right to disregard his testimony because he is accused of a crime. He at once becomes the same as any other witness, and his credibility is to be subject to the same situations as are applied to any other witness. The jury has a right to take into consideration the fact that he is interested in the results of the trial as well as his conduct upon the witness stand. In giving these instructions, it is the law of the court to simply instruct the jury as to the law applicable to the case. If you have heard any evidence in this case which the court afterwards struck out, you are to wholly disregard such evidence in reaching your verdict. The court instructs the jury that a defendant in a criminal case is not required to prove his innocence to the court. The burden is upon the prosecution to prove each and every important element of the charge made beyond a reasonable doubt, because a defendant is presumed to be innocent until his guilt is established by legal evidence beyond all possible doubt. This presumption of innocence goes with a defendant throughout the trial. In fact, you must acquit him unless you are convinced of his guilt beyond all reasonable doubt. And if you have a reasonable doubt as to his guilt, it is your duty to return a verdict of not guilty if you have any possible doubt whatsoever. Reasonable doubt is based on common sense. It is the kind of a doubt where an ordinary and reasonable person hesitates to act in the most important of his own affairs. The burden is always upon the prosecution to prove guilt beyond a reasonable doubt. A defendant has no burden at all. The law imposes no burden upon a defendant in a criminal case to prove anything, to produce any witnesses, or to produce any evidence at all. A reasonable doubt exists when, after careful consideration of all of the evidence, there is a mere possibility of a doubt. Members of the jury, when we started this trial, we talked a lot about the presumption of innocence, and each of you said, yes, we presume this person innocent. We have talked about reasonable doubt, and you have assured me that if you have any doubt based upon reason, that you would not hesitate in arriving at a not guilty verdict in this case. We have also covered the credibility of the witnesses, and you have assured me that you would consider all of the testimony of the witnesses. Once again, the court instructs the jury that the court is the sole judge of the law in this case, and it is your duty to follow the law as it is given to you by the court in these instructions. You have no right to disregard them or disregard any portion of them, but you are bound to take all of these instructions as they are given to you by the court and apply them in this case. The indictment in this case is not to be considered by you as any evidence against the defendant. It is simply the formal charge necessary to place the defendant upon trial. The presumption of innocence is not intended to aid anyone who is in fact guilty of a crime. The court has said the defendant is presumed to be innocent throughout the trial. There are two kinds of evidence, direct and circumstantial, and in my opinion, there has been both kinds of evidence introduced during this trial. Direct evidence is that sort of evidence by which a fact is proved directly and without inference from other facts, and is usually given by the witnesses who saw, heard, or otherwise observed some particular happening. Circumstantial evidence in criminal cases is a proof of facts and circumstances connected with or surrounding the crime charged, as tends to show the guilt or innocence of the party charged. If the facts and circumstances shown by the evidence in this case are sufficient to convince the jury of the guilt of the defendant beyond a reasonable doubt, then such evidence is sufficient to authorize you to find the defendant guilty. But remember that circumstantial evidence is proof of such facts and circumstances surrounding the acts and conduct of the party on trial, such as to exclude every reasonable verdict except guilt. Members of the jury, you have the right to weigh and examine all of the evidence closely and carefully in the light of your own common sense and your knowledge and your experiences in determining whether any evidence is reasonable and in determining what weight it should receive. I want to stress that the guilt of the defendant is not to be inferred because of some facts proven. You must take into consideration all of the evidence presented before reaching your final. And then we'll get ready for your 200 jury charges. You've got on your first one. Any questions on anything there, Cynthia?
No.
Okay, so on your first jury charge 200, you're going to stay on, right?
Yes, I'm going to stay on.
You have state district court, and I think district court is Drourt. Yes, district court is D-R-O-U-R-T. You have Gary Dykes and Karen Kyle. And it's called negligent attorney. Any questions?
No.
Okay, 200 jury charge number 1 for 5 minutes. Good luck. Members of the jury, in this case, the evidence has established that on September 17, 1990, following a January 3rd, 1989 dissolution hearing, the plaintiff's husband obtained a dissolution of marriage against her in an action in state district court. Plaintiff had retained the defendant, Gary Dykes, to represent her in the dissolution action. Under the terms of the dissolution agreement, all of the property which had been acquired by the defendant and her husband during their marriage and which they owned at the time the dissolution agreement was entered was given to her husband. Sometime after the dissolution agreement was entered, it was determined through judicial proceedings involving the defendant Dykes that he was negligent in his representation of the plaintiff, Karen Kyle, in the dissolution action. This negligence on the part of the defendant Dykes resulted in plaintiff Kyle losing any interest she had in the property which had been acquired by her and her husband during their marriage. In the action now before this court, plaintiff Kyle seeks to recover from defendant Dykes the reasonable value of her interest, if any, in the property which she and her husband had accumulated during the period of their marriage and which they owned on January 3, 1989, the date of the dissolution hearing. This is a civil action, and in civil actions, the party who asserts the affirmative of an issue must prove that issue by a preponderance of the evidence. By a preponderance, it is meant such evidence as when weighed with that opposed to it has more convincing force and from which it results that the greater possibility of the truth lies therein. In the event that the evidence is evenly balanced so that you are unable to say that the evidence on either side of an issue preponderates, that is, has the greater convincing force, then your finding upon that issue must be against the party who had the burden of proving it. Although the burden is on the party who asserts the affirmative of an issue to prove his claim by a preponderance of the evidence in the case, this rule does not, of course, require proof to an absolute certainty, since proof to an absolute certainty is seldom possible in any case. In this action, the plaintiff on her claim has the burden of proving by a preponderance of the evidence the reasonable value of her interest, if any, in the property which she and her husband had acquired during the period of their marriage and which they owned on January 3, 1989. Evidence is of greater weight if, when considered and compared with that opposed to it, is more persuasive and convinces you that what a party seeks to prove is more likely so than not. It is immaterial who produced the persuasive evidence. The verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdict must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence in the case with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Remember at all times, you are not partisans, you are the judges of the facts. Your sole interest is to ascertain the truth from the evidence in this case. If it becomes necessary during your deliberations to communicate with the court, you may send a note by the bailiff signed by your foreman or by one or more members of the jury. No member of the jury should ever attempt to communicate with the court by any means other than a signed writing. and the court will never communicate with any member of the jury on any subject touching the merits of the case, otherwise than in writing or orally here in open court. Bear in mind also that you are never to reveal to any person, not even to the court, how the jury stands numerically or otherwise until you have reached a unanimous decision on the amount of damages. It is proper to add the caution that nothing said in these instructions, nothing in the form of verdict prepared for your convenience, is to suggest or convey in any way or manner any intimation as to what verdict I think you should find. What the verdict shall be is the sole and exclusive duty and responsibility of the jury. Upon retiring to the jury room, you will select one of your number to act as your foreman. The foreman will preside over your deliberations and will be your spokesman here in court. If you determine that plaintiff had an interest in the property which she and her husband acquired during their marriage and owned on the date of the dissolution hearing, January 3, 1989, you should determine the reasonable value of that interest on January 3, 1989, and insert that figure in the interrogatory. The figure, if any, inserted in the interrogatory would be the amount that plaintiff is entitled to recover from the defendant. If you determine that the plaintiff is entitled to recover from the defendant, you may, at your discretion, also give her the interest on the recovery. Interest would be computed at the legal rate of 10% from September 17, 1990, and the date the dissolution agreement was entered. If interest is awarded, it is not necessary for you to okay. And then any questions, Cynthia?
No.
Okay.
Thank you.
Then we have your next jury charge, and all you do is capitalize the court. Remember, it's DORT. D-O-U-R-T, okay? This is going to be then your test number 2 for 5 minutes, and it's jury charge called negligent attorney. Capitalize court when you can replace judge in the sentence. Number 2. Members of the jury, now that you have heard the evidence and the argument, it becomes my duty to give you the instructions of the court as to the law applicable to this case. It is your duty as jurors to follow the law as stated in the instructions of the court and to apply the rules of law so given to the facts as you find them from the evidence in the case. Justice through trial by jury must always depend upon the willingness of each individual juror to seek the truth as to the facts from the same evidence presented to all the jurors and to arrive at a verdict by applying the same rules of law as given in the instructions of the court. Therefore, you cannot be concerned with the wisdom of any rule of law stated by the court. Regardless of any opinion you may have as to what the law ought to be, it would be a violation of your sworn duty to base a verdict upon any other view of the law than that given in the instructions of the court, just as it would be a violation of your sworn duty as judges of the facts to base a verdict upon anything but the evidence in the case. You are not to single out one instruction alone as stating the law, but must consider the instructions as a whole. Unless you are otherwise instructed, the evidence in the case always consists of the sworn testimony of the witnesses, regardless of who may have called them, and all exhibits received in evidence, regardless of who may have produced them, and all facts which may have been admitted or stipulated, and all applicable presumptions stated in these instructions. The term witness means anyone who testifies, and evidence as to which an objection was sustained by the court, and any evidence ordered stricken by the court must be entirely disregarded. Unless you are otherwise instructed, anything you may have seen or heard outside the courtroom is not evidence and must be entirely disregarded. Statements and arguments of counsel are not evidence unless made as an admission or stipulation. There are 2 types of evidence from which a jury may properly find the truth as to the facts of a case. One is direct evidence, such as the testimony of an eyewitness. The other is circumstantial evidence, the proof of a chain of circumstances pointing to the proof of a fact. As a general rule, the law makes no distinction between direct and circumstantial evidence. You are not limited in your consideration of the evidence to the literal words of the witnesses and other direct testimony. You are authorized to draw such inferences from the facts which you find have been proved as seem justified in the light of your experience as reasonable men and women. An inference is a deduction or conclusion which reason and common sense lead you to draw from proved facts. You as jurors are the sole judges of the credibility of the witnesses and the weight their testimony deserves. You should carefully scrutinize all the testimony given, the circumstances under which each witness has testified, and every matter in evidence which tends to show whether a witness is worthy of belief. Consider each witness's intelligence, motive, and state of mind and demeanor and manner while on the stand. Consider the witness's ability to observe the matters as to which he has testified and whether he impresses you as having an accurate recollection of these matters. Consider also any relation each witness may bear to either side of the case, the manner in which each witness might be affected by the verdict, and the extent to which, if at all, each witness is either supported or contradicted by other evidence in the case. Inconsistencies or discrepancies in the testimony of a witness or between the testimony of a different witness may or may not cause the jury to discredit such testimony. Two or more persons witnessing an incident or a transaction may see or hear it differently. An innocent misrecollection, like failure of recollection, is not an uncommon experience. In weighing the effect of a discrepancy, always consider whether it pertains to a matter of importance or an unimportant detail, and whether the discrepancy results from innocent error or intentional falsehood. After making your own judgment, you will give the testimony of each witness such credibility, if any, as you may think it deserves. The testimony of a witness may be discredited or impeached by showing that he previously made statements which are inconsistent with the present testimony of that witness. The earlier contradictory statements, if any, are admissible to impeach the credibility of the witness, and if made under oath, to establish the truth of those statements. It is the province of the jury to determine the credibility of any to be given the testimony of a witness who has been impeached. If a witness has shown knowingly to have testified falsely concerning any material matter, you have a right to distrust such witness's testimony in other particulars, and you may reject all the testimony of that witness or give it such credibility as you may think it deserves. You are not bound to decide in conformity with a number of witnesses which does not produce conviction in your mind, as against the declarations of a lesser number or other evidence which appeals to your mind with more convincing force. The testimony of one witness worthy of belief is sufficient for the proof of any fact. This does not mean you are at liberty to disregard the greater number of witnesses merely from caprice or prejudice or from a desire to weigh one side against the other. It does not mean you are not to decide an issue by the simple process of counting the total number of witnesses who have testified on the opposing sides. It means that the final test, okay, and that's it, Cynthia. Any questions on anything there?
No.
Okay, that one was better, right, than the others?
Yes.
Okay. Well, good luck, Cynthia. And don't forget, Cynthia, there's a discussion forum in your Blackboard. If you just want to, there's a new one that's going to start this week. So I'll go update it right now, okay?
Okay.
Okay. Have a nice day, Cynthia.
Same to you. Bye-bye.